Good afternoon, good morning, ladies and gentlemen, in your distinguished capacities. As introduced, my name is Juanita Nagava, and I work on the AI and Privacy Working Group within the Africa AI Policy Lab. So at the end of last year, actually during the Christmas holidays, we had the opportunity to work on the Africa AI and Privacy Report. In such a short period of time, we had a wonderful team. So without further ado, I will be giving you a summary of this report. The report is a 131-page report. I encourage all of you to have a look at the report. It is quite insightful. It addresses most of the challenges that have been indicated today, particularly in terms of privacy and data. As rightly indicated, data sits at the center of AI development. And in order for us to address some of the challenges such as bias, we have to ensure that the data is available. And for it to be available, then it has to be lawfully collected, lawfully processed. And so that's why data protection is crucial in AI development. The purpose of this report was intended to examine the intersection between AI and privacy. It was also intended to provide a comprehensive analysis of AI governance frameworks, offering insights in global and national approaches to AI regulation, and also to delve into Africa's AI policies, frameworks, and emerging trends in key areas of healthcare, education, and security, and particularly important as well in terms of AI adoption in judiciary, as has been earlier presented in the wonderful presentation by one of our members. It also assesses the adequacy of data protection in addressing or governing AI. In other words, it asks, is data protection sufficient to address the challenges that have been pointed out as far as AI is concerned, most of which have been rightly presented throughout these presentations that we have had this morning. It also outlines the pressing challenges and provides key recommendations. As far as the intersection of AI and privacy and human rights, AI relies significantly on vast training data in order for the AI systems to be to provide the correct information, in order for them not to hallucinate, as the Honorable Justice earlier mentioned to us. They need the data, and so unfortunately, the fact that the AI systems need this data, they also present privacy risks, because for most of us who may be familiar with ChatGPT and OpenAI, in developing some of the generative AI tools that they did, they had to scrape mass amount of data from the internet, and that presents privacy risks for data subjects. Another aspect that bridges data protection and AI is that one of the principles of data protection is transparency. It's a key principle under data protection law. Unfortunately, the AI systems are presenting a key problem, which is black box phenomenon. In other words, the AI systems are opaque, they're not transparent, and yet data protection law requires transparency of these systems. By opacity, it means that it's not clear, it's not easy to determine, or sometimes it's not clear in determining how an AI system has arrived at a particular decision. So I can give you an example. In 2016, DeepMind developed this tool called AlphaGo. And so AlphaGo was playing a game against the world champion in a Chinese game called Go. And so the AI system developed by DeepMind pulled a move, quote unquote, that the engineers could not have anticipated. They didn't understand how the AI system arrived at that decision. Now, when we refer to opacity, that is the opaqueness. You do not know how the system is making a decision. Now, that presents a problem with data protection that demands, it calls on and really expects transparency in order for the data subject to have control over their personal data. This also becomes a challenge as far as consent. Consent it sits at the center of data protection law. For data to be processed, there are various ways that you can collect the data from the data subject. There are various ways in which you can process this data lawfully, and one of those ways is getting consent from the data subject. This consent has to be meaningful, meaning that the data subject has to be informed. Unfortunately, once again, the systems are opaque in how they arrive at certain decisions and how they actually even collect this information from data subjects. Now, they create a challenge as far as consent is concerned. Now, that leads us to the next aspect, which is the various use cases which offer efficiency, as the Honorable Justice indicated. In the justice system, efficiency is crucial, and in other areas. However, they may also present, or rather, they may undermine privacy. For instance, in the banking sector, where they rely on customer profiling, credit risk management, as they are getting this information from the customers, they also present a risk of undermining the customer's privacy. And then there's biometric technologies and surveillance. For border control, we had a presentation on immigration. While these may be valuable to our governments in ensuring border control, they also create privacy risks. Earlier, one of our presenters indicated that when she was applying for a visa, she was asked a lot of information about her, including her children's data. Yeah, and so you see how privacy now becomes an aspect or rather a critical concern in development of AI tools. As far as human rights violations are concerned and how they relate with AI and privacy, well, it's not only privacy that is a concern with AI tools. These tools also undermine other aspects of human rights. For instance, the surveillance tools. There's a case study with Vumacam. Vumacam is a company that deployed surveillance tools in South Africa. Unfortunately, these tools are surveilling the Africans in South Africa, introducing a critical challenge as far as reminding the South Africans of the apartheid passbooks that monitor the movements of the Africans in South Africa. So you can see how it's undermining other aspects of human rights, freedom of movement, not just freedom of movement, but also freedom of expression, freedom of association. All these are also undermined when we use AI tools. They also introduce what has also been indicated, which is algorithmic bias. Can lead to discriminatory outcomes, especially when these tools rely on data that is unrepresentative. We mentioned earlier that we had a panel of bar association that is predominantly male. So you'll have to ask yourself, what will the AI tool be learning about leadership? It could learn that it is only the men that hold certain positions, and that is deeply problematic. And so that leads us to asking the question, while we have all these data protection laws, and I think African continent has done quite a good job in ensuring that we have these data protection laws, but now we have AI advancements. So we have to ask ourselves, is data protection law sufficient to regulate AI? Should we rely on our data protection laws in in addressing the issues that are emanating from AI. And a working group, we came to the conclusion that while the data protection laws provide us this foundation in regulating AI, they may be inadequate in addressing some of the complexities. For instance, the challenge with misinformation and disinformation that may not be addressed under data protection law. The disinformation, deep fakes, that emanates from misuse of generative AI tools. There's also a challenge with reinforcement of historical patterns, as I mentioned to you with the case of Vumakam, that may be reinforcing the apartheid challenges by using these surveillance technologies. So you find that some of these issues are not being addressed in the data protection laws and call on us to regulate AI. We also found that our data protection impact assessments may also not be fully, they may not fully assess human rights impacts. And so with AI systems now, they call on us to have human rights impact assessments. They also lack explicit provisions governing the entire AI lifecycle. When you look at the EU AI Act, particularly with regard to high-risk AI systems, they impose obligations on the various actors throughout the AI value chain. And this includes the providers, the distributors, and the deployers of these systems, the authorized representatives. This may be lacking, rather is actually lacking in our data protection laws, and calls on us now to go ahead and regulate these systems. We noticed that we are relying heavily on a distinct provision in most data protection laws, which is a right in relation to automated decision-making. This is provided for under Section 27 of the Uganda's Data Protection and Privacy Act and the different laws, data protection laws. Unfortunately, with advancements in AI, there is a challenge, and this takes us back to the opacity of these systems. So for instance, under the Uganda's data protection law, the right in relation to automated decision-making puts an obligation on the data controller to inform the data subject whenever a decision is made that significantly affects the data subject and is relying on automated decision making. And whenever they do that, then the data subject may request the data controller to reconsider that decision. Now, you have to wonder if the data controller cannot determine how the AI system made a particular decision, what or how effective is that reconsideration? How much more information can they provide the data subject if they themselves cannot truly understand how the AI system made a decision? The same applies with the South African law. South African law also places an obligation to provide additional information. Once again, how can we provide additional information if we cannot tell how the system is arriving at particular decision? How effective are the decisions that we are providing, or rather the decisions that we are providing to the data subject? And so we also found that there are gaps in regulatory and institutional capacity, and this is leading to AI governance becoming reactive instead of proactive. We are following and perhaps even lagging behind the tech industry in addressing the challenges that are emanating from the systems. And so we had an overview of the international governance frameworks and standards on AI. The list that is provided in this presentation is insufficient. We had a whole broad of laws and regulations. I invite you to have a look at the presentation, rather the report that is published. It is easily accessible. One of the regulatory initiatives is that of the United Nations General Assembly Resolution on AI, which was passed in 2024. This resolution urges member states to guarantee the development of safe, secure, and trustworthy AI with the respect of human rights. And particularly, it recognizes that when these systems are improperly developed, they hinder the 2030 Agenda on Sustainable Development. And so the resolution recommends that these systems should be sustainable development oriented, they should be ethical and human-centric. In the conclusion of Honorable Justice Lenaola, he emphasized the need to have people-centric technologies. As you can see, it's also reflected in the UN General Assembly resolution. We also had the UNESCO recommendations on AI, on the ethics of AI. This particular recommendation, it aims to provide a universal framework to guide states in the formulation of AI strategies. UNESCO is doing a wonderful job in working with the different governments as far as capacity building is concerned, and they continue to do so. There is then the Council of Europe Framework on Convention on AI, Human Rights and Democracy and Rule of Law. For some of us who may be familiar with Convention 108, that is the initiative of the Convention of the Council of Europe. Council of Europe is focused on human rights, and so it is therefore why the focus of this particular regulation is on human rights, democracy, and rule of law. We have noted that AI system pose a significant challenge for democratic governance in various areas, in terms of deepfakes as well, the manipulation of information in terms of misinformation and disinformation. All that poses a significant risk to democratic governance and rule of law. So the framework sets out principles for human dignity and autonomy, transparency, oversight, accountability, responsibility, equality, and data protection. More frameworks also include the OECD Principles on Trustworthy AI, the Universal Guidelines on AI that were developed during the Global Privacy Assembly conference that took place in 2018. We have a colorful presentation, shouldn't look this way. And the International Organization for Standardization has equally generated a framework. I also invite you to have a look at it. And the United Nations System White Paper on AI. So we went ahead to analyze the global governance of AI and the regulatory approaches that have taken place. One of the regulatory initiatives is once again the EU AI Act, similar to the GDPR, which took the center stage in regulating emerging technologies. This particular regulation is much more comprehensive and structured. It intends to promote the uptake of human-centric and trustworthy AI while ensuring the protection of health, safety, and fundamental rights of individuals. It adopts a risk-based approach. By risk-based approach, it means that it regulates the technology based on the risks that is associated with the particular technology. And so it classifies the risks as prohibited. This includes social scoring, purposefully manipulative systems, high-risk AI systems. You can find these in Annex 3 of the Act and Annex 1 of the Act as well. This includes education, critical infrastructure. There are very strict obligations as far as high-risk AI systems are concerned. It imposes obligations on the providers of the systems, the deployers, and authorities representatives. Some of these obligations include data governance, record keeping, transparency, and a host of others. The limited risk systems include chatbots, and the reason why they're regulated is because they may be deceptive. We also have the low-risk systems such as spam filters, because they present a limited risk. And finally, we have the general-purpose AI systems. The United Kingdom does not have the comprehensive approach that Europe is taking. Instead, it's relying on its existing laws such as consumer protection, data governance, and non-discrimination. It also has supportive tools and resources to facilitate the startups and the tech industry in developing their tools. Ultimately, the United Kingdom seeks to balance the promotion of AI while mitigating the risks that we have identified throughout this presentation. On the other hand, the United States of America takes a different approach, which is a multifaceted approach. They have very many regulations at federal level, at legislative level. They have non-binding frameworks, state level initiatives, such as the New York State AI Bill, California AI Transparency Act, the NIST AI Risk Management Framework. So they have a variety of these regulations. So it's taking this multifaceted approach as opposed to the more centralized approach that the Europe has taken. Ultimately, the United States intends to be a global leader in AI, in the AI revolution, as was witnessed by the revocation of the executive order on the safe and secure, trustworthy AI that was developed by Joe Biden. In South America, we notice that there are similarities between South America and Africa. Within this continent, there are only 6 countries that have AI strategies, and that is Brazil, Colombia, the Dominican Republic, Peru, Chile, and Uruguay. China, there are a lot of advancements that are taking place with China, but they are also quite proactive in developing regulations on AI, and this includes the provisions on the management of algorithmic recommendations, the deep synthesis management provisions. This particular regulation obligates the providers of these systems to mark systems that generate fake output, fake images, so that they do not cause confusion. China also has a proposed AI law that should be coming into force. Ultimately, our findings suggested that there's a broad spectrum of strategies that the different countries are undertaking. Ultimately, they intend to balance innovation, economic growth, and ethical considerations. We also noticed that there are certain countries that are focused more on global leadership, and as we noticed, that is the United States and Saudi Arabia, as much as I had not earlier indicated the advancements on the advancement in Saudi Arabia. But Saudi Arabia is particular on ensuring that it has global leadership. Others are taking the approach that is sector-specific, like Israel, while the EU is taking a more comprehensive, perhaps even strict and structured approach. The less centralized approach is that of the United States of America. These varying approaches demonstrate that each of the countries have different values and priorities. And so Africa's strategy to AI governance, this was earlier presented by the earlier presenter. The continental strategy was endorsed in 2024, and it intends to demonstrate a commitment, it demonstrates a commitment to Africa-centric, development-oriented approach to AI. It also calls on the unified national approaches among the AU member states, and particularly this is because of the lessons that we learned in data protection regulation, which was much more fragmented and inhibited legal certainty. So it proposes a framework that is people-centric, development-oriented, and inclusive. So within the regional approach, the East African region, it's a lot more nascent. As earlier also indicated, Rwanda has a national AI policy, and they intend to ensure that it aligns with the 2050 vision of the country. Kenya as well has a national AI strategy. Uganda has a national fourth industrial revolution strategy, the big data strategy, digital transformation strategy, and is yet to develop a specific strategy that is specific to artificial intelligence. In West Africa, Nigeria has a national AI policy, Ghana has a national AI strategy, Benin as well has a national AI strategy, and big data. In North America, Egypt is equally proactive. in its national AI strategy that recognizes the potential of AI to improve healthcare, agriculture, and transport. It had its first edition of the strategy in 2020, but the same was amended, and they have a second edition, which is 2025 until 2023. Once again, we see another country that intends to have leadership in AI. So with Egypt, they intend to be a leader in the entire MENA region. Southern Africa, there are developments with South Africa as well. They have a draft cloud and data policy. They have a national AI policy, while Zimbabwe as well has a national AI policy framework. So what did we find out? We found out that, once again, AI is double-edged sword. So the adoption of AI in Africa has both opportunities and challenges. And African countries ultimately want to harness the transformative power of AI to drive economic growth and enhance social outcomes and promote equitable and inclusive future for all. So we're trying to see that AI can enable us to leapfrog our immediate challenges, and so that we are as competitive as the other countries on the globe. We also found that there are diverse strategies that have been adopted in regulating AI. In terms of recommendations, we recommend, as has been earlier noted, to collaborate and share the best practices. There is need to refine our policies to ensure that AI-driven growth remains ethical, inclusive, and beneficial for all. We recommend a pan-African approach to AI governance that would enhance legal certainty, foster innovation, prevent regulatory fragmentation. There is need to strengthen regulatory capacity, and we recommend regulatory sandboxes and public awareness. So I'd like to thank you very much, I know it's lunchtime, for paying attention throughout this presentation. Once again, the report is available. I do encourage you to have a look at it. It's only 131 pages, but I trust that you will have a look at it. Thank you very much, and have a wonderful day. Thank you.